Good morning, ladies and gentlemen. I'd like to welcome you to County Court Level 2. My name is Judge Terrence Holmes. I'm the presiding judge here at County Court Level 2. This morning, you have been asked the court to come today for what is called an arraignment. And what the arraignment is an opportunity for the court to tell you what you've been charged with, what your rights are, what your options are concerning your case. Now, the case that you have in this court is a misdemeanor case. Is a criminal misdemeanor case. Criminal cases are divided into felonies and misdemeanors. Now, your felony cases are normally referred to as your more serious type offenses, whereas your misdemeanor cases are normally referred to as your petty offense. Does not mean that they are not as serious. It just means that they are not as serious as a felony case. Now, when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can get if they are convicted of the offense. Now, felony cases are divided into 5 categories. We'll start at the top, work our way on down to the bottom. You have the capital murder, first degree felony, second degree felony, third degree felony, and the state jail felony. Now, if a person is convicted of a state jail felony, the punishment is minimum 6 months to a maximum of 2 years in the state jail and a fine that does not exceed $10,000. If a person is convicted of a third degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a second degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a first degree felony, the range of punishment is minimum 5 years to a maximum of 99 years or life in the state penitentiary and a fine that does not exceed $10,000. Or if a person is convicted of the highest felony, which is a capital murder, the range of punishment is life in the state penitentiary without the possibility of parole or death by lethal injection. Now, as I mentioned to you earlier, you have a misdemeanor case, so you don't have to worry about those type of punishment. Now, misdemeanors are divided into 3 categories. We'll start at the top, work our way down to the bottom. You have the Class A misdemeanor, Class B misdemeanor, and the Class C misdemeanor. Now, the Class C misdemeanor are cases that start in the city court or the JP court. They come to this court when a person is convicted in the JP court or the city court, and then they appeal their case. In essence, they get a whole new trial in this court. Now, the range of punishment for a Class C misdemeanor is maximum fine of $500. You cannot be given any jail time. You only can be given a fine from $1 to $500. Now, if you fail to pay the fine, or if the fine was converted to community service and you fail to perform the community service at a nonprofit organization, then the court can issue something that is called a capias pro fine. It's a warrant for your arrest for you to either pay that fine or sit the fine out in jail. Now, if you sit the fine out in jail, you'll be given credit for $100 for every day that you sit out the fine in jail. Now, the next highest misdemeanor is Class B misdemeanor. With the Class B misdemeanor, the range of punishment is minimum 0 days to a maximum of 180 days in the county jail, or you could be given a fine that does not exceed $2,000, or you could be given both such jail time and a fine. Now, the highest misdemeanor is a Class A misdemeanor. With the Class A misdemeanor, the range of punishment is 0 days to a maximum of 365 days in a county jail, or you could be given a fine that does not exceed $4,000, or you could be given both such fine and confined in the jail. Now, everyone that's here for arraignment, you should have a clipboard. And I'm going to go over the paperwork on that clipboard. Now, the first document should be titled Judge's Explanation of Rights to Defendants Without Attorney. that document looks like this. Okay? Judge's explanation of rights to defendants without attorney. I will continue and keep referring back to this document. Now, it states that as a defendant in a criminal case, you have three options. Number one, you may hire an attorney. Number two, you may request that an attorney be appointed to represent you. And number three, you may represent yourself. Now, the first sentence states that if you want an attorney, you have enough money to hire an attorney, then your case will be reset to give you time to hire your attorney. The next sentence states that if you want an attorney, but you do not have enough money to hire an attorney, then you may request or you may ask that an attorney be appointed to represent you. But you must first fill out a financial questionnaire so that the proper person can determine whether or not you qualify for a court-appointed attorney. Now, the financial questionnaire is a 3-page document that's on the clipboard. Only individuals who will be applying for a court-appointed attorney will fill out this document. If you are not applying for a court-appointed attorney, you will not fill out this document. You don't have to listen to what I'm getting ready to say. Now, for those individuals who will be applying for a court-appointed attorney, you will fill out the first page of this document that's titled Jefferson County Affidavit of Indigence. You fill out the first page, and then you'll go to the second page. The second page at the top, it says Defendant's Oath. You'll fill that portion out, and then you'll go to the middle portion that's titled Unsworn Declaration by Defendants. You'll fill that out, and then you'll stop. Now, referring back to the first form, judge's explanation. The third paragraph is for individuals who would like to represent themselves. In essence, they would like to waive their right to an attorney, which means to give up their right to an attorney and represent themselves. If you would like to do that, then it states, then you'll have an opportunity to talk to one of the 3 prosecutors. Prosecutors are assistant criminal district attorneys that work for the Jefferson County District Attorney's Office. You'll be able to talk to them. And why you'll be able to talk to them? Because if you had a lawyer, your lawyer will be able to talk to them on your behalf. But since you're representing yourself, you are your own lawyer, so you'll be able to talk to them on your own behalf. Okay? Now, before you're able to do that, this is only for individuals who will be representing themselves. You have to first fill out a document that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. This is a 1-page document that is also on the clipboard, and this is only for people who will be representing themselves. You have to fill out this document, and then you'll sign at the bottom where it says defendant and the day's date. Okay, going back to this first document. There's a paragraph in block form near the bottom of this document, and this is only for individuals who will be representing themselves. And it states that, be aware that the dangers and disadvantages of self-representation, waive your right to an attorney, and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities related to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to represent yourself, the last paragraph states that you may change your mind at any time and request that an attorney be appointed to represent you. Now, at the bottom of this document, everybody is going to make a choice. There are 5 lines to the left at the bottom. If you would like to hire your own attorney, then you'll place your initials on the first line to the left, and then you'll sign the bottom of the form where it says defendant and you place today's date. If you would like to, well, if you have already hired an attorney to represent you, Then you'll place your initials on the second line to the left, and the name of the attorney on the line to the right. And then you'll sign and date this form, and this is the only form that you would have to sign. All right. For those of you who would like to apply for a court-appointed attorney, you will place your initials on the third line to the left, at the bottom, third line to the left. Place your initials there, and then you will have to fill out this document that I mentioned to you earlier, that is titled Jefferson County Affidavit of Indigence. You'll fill out the first page. You go to the second page, you'll fill out the top portion that's titled Defendant's Oath. And then you'll fill out the middle portion that's titled Unsworn Declaration by Defendant, and then you'll stop. Now, if you have already been appointed a court-appointed attorney in your case, then you will place your initials on the fourth line to the left, and the name of the attorney on the line to the right. If you would like to represent yourself, that is, give up your right to have an attorney or waive your right to have an attorney, and you would like to represent yourself, then you'll place your initials on the fifth line at the bottom to the left. You will sign and date this form, and then you would have to read and sign the form that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. So, at a quick recap, if you'd like to hire your own attorney, this is the only form that you would have to sign. Place your initials on the first page, sign and date it, and stop. If you already hired an attorney to represent you, this is the only page that you would have to sign. Place your initials on the second line, sign and date it, and then you'll stop. If you would like to apply for a court-appointed attorney, then you would place your initials on the third line, sign and date it, and then you would have to fill out the form. First two pages of the form that is titled Jefferson County Affidavit of Indigence. And if you've already been appointed a court-appointed attorney, you'll place your initials on the fourth line, sign and date it. The name, write the name of the attorney on the line to the right, and this is the only form you have to sign. If you would like to represent yourself, that is, waive your right to have an attorney, then you will place your initials on the fourth line, on the last line, the fifth line to the left, sign and date it, and then you will sign, read and sign the form that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Okay, do we have any questions? No questions. All right. Now, I'm going to give you time to fill out that paperwork, but in the meantime, I need to go over some of the rights that you have. One other right that you have is, well, first of all, you can enter a plea of, one of three types of pleas. You can enter a plea of not guilty. If you enter a plea of not guilty, you're telling the court that you did not commit the offense that you have been charged with. Or you can enter a plea of guilty. If you enter a plea of guilty, you're telling the court that you committed the offense that you've been charged with. Or you can enter a plea of no contest. If you enter a plea of no contest, you're telling the court that you would not be contesting the charges, or you would not be fighting the charges that they have against you. All right. Now, I mentioned to you earlier, I talked to you about the three types of pleas. But also, I talked to you about the punishment range for Class A, Class B, and Class C misdemeanor. Also, you may be eligible for probation. There are two types of probation. One type of probation is called unadjudicated probation. Unadjudicated probation. And what that means is we commonly refer to it as deferred adjudicated probation. And what that means is you don't have a conviction on your record. And if you're successfully completed, the case will be dismissed, and you can get what is called a non-disclosure. Non-disclosure is where your record will be sealed to the general public. The general public cannot have access to the case that you have a non-disclosure on. Now, the operative word that I've used was general public. So that means that the If it's not the general public, like if it's a governmental agency listed in the Texas Code of Criminal Procedure, they can have, certain governmental agencies can have access to your record. Even though you have a non-disclosed, like, for example, police department. All right, now, the other type of probation, we say we had unadjudicated probation. The other type of probation is called adjudicated probation, unadjudicated probation and adjudicated probation. With adjudicated probation, we call it regular probation. It does result in a conviction on your record. However, there's something that is called judicial clemency, whereby the judge or the court can set your conviction aside. You will no longer have a conviction. Okay? Now, however, if you get a subsequent conviction, another conviction later on, then the case that you receive judicial clemency on can be resurrected. It can be brought back up. It can be revived. It can be used against you. And if you try to get a license with CPS, they can deny with just CPS Child Protective Service. If you try to get a license with CPS, they can deny giving you a license, or if you have a license, they can revoke or suspend your license. All right. Now, you also have a right to have a trial. You can have a trial by jury. For those young people in the city, we call that the jury box. 6 citizens from Jefferson County will be selected to serve as jurors in your case. They will listen to the evidence that's presented by the state of Texas, listen to the defense that's presented by the defendant. They will listen to the arguments of the state of Texas, to the arguments of the defense, and then they will go right back into that jury room in the back, and they will deliberate. And they can either find you not guilty or guilty. Now, you can waive or give up your right to have a jury trial, which means that you're saying that you don't want to have a jury trial. Now, you can waive or give up your right to have a jury trial. You still can have a trial. Somebody said, well, how can I have a trial if I don't have a jury? You can have what is called a bench trial. What a bench trial is a trial by judge only. The judge will be the judge and the jury in the case. The reason why they call it a bench trial is because the judge sits on the bench. So they call it a bench trial. Now, the judge will listen to all of the evidence that's presented by the state of Texas, listen to the defense that's presented by the defendant, the state. The judge will listen to the arguments of the state of Texas, listen to the arguments of the defense, and then the judge will apply the facts of the law and decide whether to find you either not guilty or guilty. Now, you can waive and give up your right to have a trial at all, a jury trial or a bench trial. And you could simply enter a plea of guilty in no contest and try to work out a plea bargain with the state. There are 2 types of plea bargain. One is called an agreed plea bargain. Agreed plea bargain. That just simply means that you and the state of Texas have reached an agreement to settle your case. And if you have reached an agreement to settle your case, then your case will come before the judge, and the judge can do 1 or 2 things. The judge can accept or reject the agreement. Now, if the judge accepts the agreement, and let's say within 30 days, you would like to file a motion for a new trial on appeal, then if you want to appeal your case, you have to get permission from the judge that followed the plea bargain agreement. Now, if the judge gives you permission, the case is going to leave this court. And it's going to go to another court. It's going to go to a higher court. A higher court is the 9th Court of Appeals, which is ironically right above us on the 3rd floor. There are 4 judges there, and they will listen to the evidence. Now, what they will do is they will review your case. They can grant or deny your appeal. If they grant your appeal, they can simply find you not guilty. Case over. Or they can send the case back down to this court or to this court to give you a new trial. If they deny your appeal, guess what? You can appeal it to a higher court than the 9th Court of Appeals. You can appeal it to the highest criminal court in the state of Texas, which is the Court of Criminal Appeals, and they're located in Austin, Texas. Now, you have to file what is called a pro se petition for discretionary review. What that means is this. Pro se means self, by myself. In essence, you'll petition the court. You don't have an attorney doing it on your behalf. It's a pro se petition. So you'll petition the court to review your case, to see whether or not your appeal should be granted or whether or not this court committed an error by convicting you. And then what they will do, they can either grant or deny your petition. If they grant your petition, they can simply find you not guilty, case over. Or they can send the case back to the Ninth Court of Appeals with orders, or they can send it back down to this court with orders. Now, if they deny your pro se petition, then at that point, your conviction will stand. All right. Now, you not only have a right to have a trial, well, a trial by jury or by judge, you also have a right to have witnesses that come to court to testify. Witnesses, they sit in that chair that have the microphone in front of it. We call that the witness stand. They can testify for you, or they can testify against you. If you represent yourself, you can ask them questions. Or if you have an attorney, your attorney can ask them questions. We call that either direct examination or cross-examination. Now, you can waive or give up the right to have witnesses, which means you will not be calling witnesses. Does not mean that the state will not be calling witnesses, because they will be calling witnesses in the case that they have against you. Now, you also have what is called a Fifth Amendment right against self-incrimination. Now, the Fifth Amendment of the United States Constitution gives us the right to remain silent. And that's just, we don't have to say anything that will incriminate. Okay. So I know a lot of times we watch television, we see the television lawyer go up to the witness stand and ask the witness a question, and the witness say, I take the fifth. Right? What they're saying is, I'm invoking my Fifth Amendment right, I'm exercising my Fifth Amendment right to the United States Constitution to remain silent. Now, if you think about it, it makes sense for us to have a Fifth Amendment right to remain silent. Why? Because the state of Texas, the district attorney's office, the government, has the burden of proving you guilty. You don't have to prove yourself guilty, okay? They have to prove you guilty. So if you want to exercise your Fifth Amendment right against self-incrimination, you have a right to do it. Okay. Now, you also have a right, the last one I'm going to talk about is your right to have discovery. And discovery is the right to see the evidence that's in the state's file. Okay? You have a right to see your statements, witness statements, police reports, lab reports. You have a right to see photos, video recordings, right to listen to audio recordings, a right to have access to any type of instruments or documents that the state may have and will be used against you in your case. You also have a right to waive or give up the right to have discovery, which means you can say, well, I don't want to have access to it, I don't want to see it. Okay. Now, everybody that's here for court today, charges was filed against you, you was arrested, you placed in jail, you're out of jail on bond, you're either out of jail on a cash bond, which means that you pay the full amount of the bond to get out of jail. You might be out of jail on a surety bond, which means you're paying a bondsman a percentage of the bond to get out of jail. Or you may be out of jail on what is called a personal recognizance bond or a PR bond, which means that you did not have to pay any money to get out of jail. You were just released on your own personal recognizance with a promise to appear today. I'm saying that to say this. Every day that you spent in court, every day that you spent in jail can be used as credit toward your punishment. So, for example, let's say you spent 5 days in jail. And let's say the state is offering you to serve 5 days in jail as part of the plea bargaining agreement. That means you don't have to serve any more time in jail. Why? Because you'll be given credit for the time that you have already served. Now, if you serve 7 days, if you serve 5 days in jail and they're offering 7 days in jail, that means you only have to serve 2 days in jail. Why? Because you already have 5. We subtract 5 from the 7, that leaves 2. Now, every day that you spend in jail also can be used as credit towards your fine and court costs. As I mentioned to you earlier, you get $100 for every day that you spend in jail, $100 credit. So if you spend 5 days in jail, that's $500 credit that can go toward your fine and court costs. So if the state is offering you fine and court costs of $500 and you spend 5 days in jail, guess what? You don't have to pay anything because the 5 days that you spent in jail has already paid it off. And so the $500 will be taxed and retired. Now, if they are offering fine and court costs of $700, then you would only have to pay $200 because you have $500 credit. That will be subtracted from the 7 that leaves 2. Now, you'll be required to pay the $200 on the day that you do the plea. Now, if you cannot pay it on the day that you take care or dispose of your case, no problem, because we can put you on what is called a payment plan. And you can pay it off in small monthly installments until it's paid off. Now, for some people, they may not have had an income to pay off a payment plan. No problem. We can convert it to community service. And so for every 1 hour of community service that you perform at a nonprofit organization, $12.50 will be credited toward your fine and court costs. It's almost like making $12.50 an hour. Okay? And so you work 8 hours one day, that's $100. So in our scenario, you work 2 8-hour days, that's $200. Your fine and court costs is paid off. Okay? Now, Jefferson County District Attorney's Office has a program for people that have not been in trouble before. If your first time, this is your first time getting one case or more than one case. And Jefferson County has a program that is called pretrial diversion. And what that means is this here. They will dismiss your case. And then once they dismiss your case, you can get it wiped off your record. We call it expunction. Okay? And we no longer put on your record like it never happened. Now, in order to qualify for the program, one, you have to get an attorney to assist you in getting in the program. The attorney could be a court-appointed attorney, not have to be hired. All right. 2, it has to be your first time getting into trouble with the law. And then 3, it cannot be an offense for unlawfully carrying a weapon or resisting arrest. Now, if you qualify for the program, like I mentioned to you earlier, if you get into the program, case is dismissed, complete the program, you can get it. The case is dismissed, you can get it erased, deleted, or wiped off from your record like it never happened. Now, if you're a veteran of any one of the branches of the United States military, the District Attorney's Office has another program for veterans only. This program is called Veterans Court. And with that program, once you get into the program and complete the program, they will dismiss the case. And you can get a non-disclosure on that, where your record is sealed to the general public. Now, this court, County Court at Law Number 2, Jefferson County, Texas, has a program that God led me to start within the first 100 days of taking office. The program is known as the CSI program. CSI stands for Community Safety Initiative. That program is designed to address the issue of what is called recidivism. Recidivism means people committing crimes over and over. And so how do we address it? We address it through the CSI program. And with the CSI program, we have partnerships with agencies in our community. And one of the agencies that we have a partnership with is the Spindletop Center. We have some individuals from the Spindletop Center that will come to you in a few minutes and tell you a little bit more about the program. But basically, the Spindletop Center is our local mental health center in the Southeast Texas region. They have the expertise to address mental health issues that individuals may have. Now, you don't have to be incompetent or insane to participate in the program. You can just simply suffer from depression or anxiety or any other host of mental illness, and they have the expertise to address those issues. If you have problems, with drugs or alcohol, well, They also have a drug and alcohol recovery program. It's called ATAR. ATAR, ATAR is an acronym that stands for Addiction Treatment and Recovery. We also have a partnership with the Golden Triangle Empowerment Center that has a program that is called OSAR. OSAR, OSAR, is an acronym that stands for Outreach Screening and Outreach Screening Assessments and Referral. Both of those programs, ATAR and OSAR, are recovery programs whereby they will do a screening and then an assessment to determine what the problem may be, and they will develop a treatment plan. And with the mental health program, that Spindletop will do an interview. It could be a private interview, either in our jury room, at their facilities, or by telephone, whichever is convenient for you. They will also do an assessment whereby they will determine what the mental health issue is, and they will develop a treatment plan for either outpatient or inpatient treatment. Now, if you are unemployed, or if you're looking for a better job, well, we have a partnership with the Golden Triangle Empowerment Center. We have a partnership with Lamar University. Lamar University has a program that is called CICE. It's an acronym that stands for Center for Innovation, Commercialization, and Entrepreneurship. It's a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you're trained in any one of those areas that you select, they will help you to get a job in the area that you're trained in. Now, if you have not graduated from high school, or if you do not have your GED, graduate equivalency diploma, then they will help you to get your GED because they have a GED program. Now, all of these programs that I just mentioned to you are free. It does not cost you anything but time. And like to say in this court, we don't just give time. We take our time. That is, we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so I like to say that when you come to County Court at Law Number 2 in Jefferson County, Texas, we don't have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of individuals that come before this court. And if we make a difference in their life, we'll make a difference in the community. And if we make a difference in the community, we'll make a difference. If we make a difference in here, then we'll make a difference in their home. And if we make a difference in their home, then we'll make a difference in the community because what comes out of the home goes into the community. So if you're interested in the program, just let us know. We have brochures and we have people that you can talk to get you started on the journey of living your best life. So at this time, as I mentioned to you earlier, we have some folks from Spindletop. They're going to come and talk to you a little bit more. We have Tanya and we have Danny. They're going to come and tell you a little bit more about the program that they have to offer.
We've all built in, or we've all in, what guy on these on there. Really cool part about these. I'm Deputy Powell, I'm a health deputy for Spindletop. Actually, that's the sheriff's office, but I spend my time with Spindletop every day. It's about she qualified as a mental professional upon you do set. And they did a program 9-10 years ago. We partnered with the sheriff's office, we probably partnered together. Because this program to help you meet help with disability in the community and often emergency. And we've all day together, we go through the houses, we talk to them. As much as we can to be citizens and Actually, from last 10 years, been looking out the board. Tommy's gonna go over the paperwork, then we'll get it out. And then she might need to. She was on, she was on.
Y'all, as he said, we're together all day, every day, so it's like family somewhat. As he said,
Fill this thing out, have to just not help your case, just to help yourself. You wouldn't go on for long.
but we do want to see this part off at your order. Just depending on what you guys need, if you do need services, as that be called and Judge Holmes said, we can assist you guys with mental, we can assist you guys with substance abuse, or sometimes even help. When I say help, if you guys need some information as to where to find a doctor, depending on what the situation may be. If you needed transportation, myself and two other qualified professionals and two other deputies, we can do transportation. It just depends on what you guys need when you go to them. To be honest, appointments are a little far out, but at the same time, we can call ourselves ASAP. The ASAP, we can be there for you to start it. If you need a super, it could be anything from suicide, it could be anything from substance abuse. Or if you guys are in jail, we are in court, we also come to the jail and do assessment as well. With this form, if you guys would rather, I also do text. Not everybody wants to communicate face to face. Not everybody wants to communicate over the phone. Sometimes it's easier to speak through text. If you guys want to fill out, you can go ahead and fill out the sheet and then we'll come back and be us. No judge, I have to look for you. Questions?
Who is that? What's his name? Not Hendricks. Okay, Mr. Barado, you're not supposed to be eating. You're in court. I mentioned to you that earlier. Okay.
Okay, ladies and gentlemen, the paperwork that you have, in your hands, we're gonna give you time to fill the paperwork out. It's gonna take a few minutes to fill out. If you need help with filling the paperwork, we have our core personnel who's here, including myself, who'd be happy to assist you with filling the paperwork out. Now, once you finish filling out the paperwork out, we're gonna pick it up and we'll go over and make sure it's filled out properly. And then we're gonna call you up before the bench, one at a time. We're gonna put you into one of three categories. One category is if you like to hire your own attorney, then your case will be reset today to give you time to hire your attorney. If you would like to apply for a court-appointed attorney, then if you qualify, your attorney will be appointed today. All right? And if you would like to waive your right to an attorney and represent yourself, you have an opportunity to talk to the prosecutors about your case to see if a settlement can be working out. If you're able to work out a settlement, your case will be taken care of today. All right? Now, it's gonna take us a little time for you to fill out the paperwork, for us to look at, evaluate it, and then have you come up. If you need to use the restroom, there are two restrooms right out in the hall. And we have the men's restroom in front of County Court 11-3, which is right next door to us. And the women's restroom is on the opposite side of the hall, from County Court 11-3, is in front of the 172nd District Court. Now, you'll be allowed to use the restroom. Please do not leave the courthouse. If you leave the courthouse, and we call your name, and you're not here, warrant is gonna be issued for your arrest. You will be arrested, placed in jail, probably bound out, and guess what? We have to go through this thing all over again. And so, to avoid that, just be mindful that It's gonna take us a little time to fill out the paperwork. You'll be allowed to go use the restroom and make sure that you come back in the courtroom. Anybody have any questions? Oh, on that first form that's titled Judge's Explanation of Rights of Defendants Without Attorney, at the top it says State of Texas versus blank. Print your name on that line. The reason why we say print, because some people's signatures we can't read. Sometimes I can't read my own signature. Okay? So make sure you print your name so that we'll know whose form it is. All right? So at this time, the court is gonna be in recess. Conduct yourself accordingly. We're still in court, but the court is gonna be in recess. Okay, at this time, I'll put you in the hands of Miss Barilla Boycat.
Anybody?
Okay, what's the dates?
$20.
April 21st?
Not.
Okay, now, Mr. Barado and Mr. Hendricks, your cases are reset to April, what? April 21st at 9 a.m. Okay, on that day, you need to be in court in person. There's some paperwork that you need to fill out, okay? So at
Okay.
this time, you're free to go. And Mr. Barado, you have a blessed day. Mr. Hendricks, you also have a blessed day.
You too, sir.
Okay,
Yes, sir. Thank you.
all right.
Jefferson County Court of Law number 2 is back in session. The court is in session. And cause number 26CCCR0098. Case is styled the state of Texas versus Timothy Dalton Jennings. Mr. Jennings, please come forward. Mr. Jennings, your full name is Timothy Dalton Jennings. Mr. Jennings, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Jennings, you may put your hand down. How are you doing, Mr. Jennings? I'm doing fine, thanks for asking. Now, Mr. Jennings, I have before me a document that is titled, Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes.
Is this your signature on the line that's titled defendant?
Yes.
And are these your initials on the line that state you'd like to have your case reset to hire your own attorney? Now, Mr. Jennings, before you sign and initial this document, did you read the document?
Yes.
Did you understand what you read?
Yes.
And is everything in this document true and correct to the best of your knowledge? Okay, Mr. Jennings, your case will be reset to give you time to hire your own attorney. Our court coordinator is going to reset your case. Once she resets your case, you'll be free to go and you have a blessed day. Please stand in front of the court coordinator for your reset. Thank you. Latressa Marks.
You too.
Ms. Marks, your full name is Latressa, is that Meineke?
It doesn't even matter, but it's supposed to be Monique.
Monique,
Yeah.
okay?
Oh.
So that's Latressa Monique Marks.
Mm-hmm.
Okay, Ms. Marks, would you please raise your right hand? Your hands, ma'am.
Oh, my
Do
bad.
you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Marks, you may put your hand down. How are you doing, Ms. Marks? You doing fine?
Yes.
That's good. Now, Ms. Marks, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Or are these your initials on the line that state you would like to have your case you would like to have your case reset to hire your own attorney? Now, Ms. Marks, before you signed and initialed this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge? Okay, Ms. Marks, I read your answers. Now, Ms. Marks, your case will be reset to give you time to hire your own attorney. Our court coordinator is going to give you a reset. Once you get your reset, you'll be free to go and you have a blessed day. Please stand in front of the court coordinator. Case in Morris. Mr. Morris, your full name is Case in Morris?
Jason, yeah.
Okay. Mr. Morris, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Morris, you may put your hand down. How are you doing, Mr. Morris?
Very good. How are you?
I'm doing fine, thanks for asking. Now, Mr. Morris, I have before me two documents. The first document that I have is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant?
Yes, sir.
Or are these your initials on the line that states you'd like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Injuries. Do you recognize this document? On page 2 of the same document, there's a signature above the line that is titled defendant's signature. Is this your signature?
Yes, sir.
Now, Mr. Morris, before you sign and initial this document, or these documents, Did, you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Ms. Morris, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that would be appointed to represent you in this case is Attorney Jack Lawrence. Attorney Lawrence will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat in that chair on the wall. Gary Hafford. Mr. Hafford, your full name is Gary Hafford?
Gary Lee Heifer Jr.
Okay, Mr. Hafford, don't lean on the bench. Please raise your right hand. Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You may put your hand down. How are you doing, Mr. Hafford?
I
I'm doing fine, thanks for asking, Mr. Hafford. I have before me two documents. First document. Okay, first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Could you show this document to him? She's gonna show you those documents. You should be up a little closer. You recognize those documents? And I think you have someone here with you. Ma'am, would you please come forward? How you doing, ma'am? And what's your name?
Belinda Hatcher, I'm his sister.
His sister? Okay. Now, Miss Belinda Hafford, you helped, well, first of all, how are you doing?
I'm doing good.
All right. Now, you helped Mr. Gary Hafford to fill out the paperwork?
Yes, sir.
Okay. Now, Mr. Hafford, that paperwork that you have before you, your sister helped you to fill out that paperwork, is that correct?
Yes, sir.
And is everything in that paperwork true and correct to the best of your knowledge? Okay, now, Mr. Hafford, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in your cases is Attorney Todd LeBlanc. Attorney LeBlanc will be given information to contact you, and you will be given information to contact him. Our court reporter will give you that information. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Now, let me do this here before you leave. Let me turn this down. Now, Mr. Hafford, once you get your reset, you're gonna be free to go. And you have a blessed day, and you have a blessed day as well, ma'am. You're welcome. Yes. What's the first case? What's the other case? What's the offense? Yeah. Oh, excuse me. Okay, Mr. Bobineau. Your full name is Antoine J. Bobineau? Would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Babineau, you may put your hand down. How are you doing, Mr. Babineau? I'm doing fine, thanks for asking. I'm Mr. Babineau. I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant? Are these your initials on the line that states you'd like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there is a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
Now, Mr. Babylon, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Mhm.
Now, Mr. Bobineau, let me do this here. I'm gonna turn this here off. I need to if, we just look at if it was just a 40-hour week, you make about, I'm just looking at the gross, would be about, 4,680 if it's 52 hours a week. I mean, 50, hours. It would be 6,435. Okay. You don't qualify for a court-appointed attorney. Okay. Yeah, because you make anywhere between, well, I'm not gonna air that out on YouTube, but you don't qualify. You make too much. Okay. Okay, now, at this point, you can, have your case reset to hire your own attorney. Or you can, waive your right to attorney and represent yourself, okay? So, I'll let you, you hire, okay. But what he needs to do is, he's gonna place his initials on the top line, on the first line to the left, at the bottom.
Yes.
Okay. So, your case is gonna be reset. Let's give you time to hire, your attorney. All right? All right, yeah, just have a seat in that first chair on the wall. You have a blessed day. I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
Are these your initials on the line that state you'd like to waive your right to an attorney and represent yourself?
Yes, sir.
I also have another document that is titled Waiver of counsel for purposes of entering a guilty plea or proceeding to trial. You recognize this document? And is this your signature online as title defendant?
Yes.
Now, before you signed and initialed these documents, did you read the documents? Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge? Now, Mr. Goda, I understand that, you talked to the prosecutors about your case, is that correct?
Yes, sir.
And you were unable to come up with an agreed plea bargain agreement. Is that correct?
Yes, sir.
Now, at this point, you have, I guess, two options. You can proceed on what is called an unagreed plea bargain agreement, or you can have your case reset for trial. Do you understand?
Yes, sir.
Now, what do you want to do?
No, I've got myself case reset for trial.
For trial, okay. Now, before your case is reset, I need to go over what is called a Faretta warning. This is pursuant to the case of Faretta versus California, 422, United States, 806. And it state, well, first question is, have you ever studied law?
A little bit.
Little bit, okay? Have you ever represented yourself in a criminal action?
Yes, sir.
Sir, okay. Do you understand the charges against you? Okay. And let's see, are you aware of the penalty range?
Yes, sir.
You are, okay, it's a class A misdemeanor. Are you familiar with the exact legal elements for each charge? That is what the state has to prove?
Mhm.
And what are they?
What arguments?
What are the elements of your charge? What does the state have to prove?
Well, that detective service,
Okay, so what are the elements? What are the elements of the offense?
particularly pertaining to what?
You said you understood the elements, you knew the elements of the offense.
No, plus you're concerning about that it was detective service.
So you don't know the elements of the offense. So you don't know what the state has to prove, okay. Do you realize that if you represent yourself, you're totally on your own as a judge? I cannot tell you how you should try your case or even advise you as to how to try your case. Do you understand that?
Yes, sir.
I cannot help you in any way. You understand that? Now, are you familiar with the Texas rules of evidence and Texas case law? Do you realize that the Texas rules of evidence and Texas case law govern what evidence is admitted? And in representing yourself, you must abide by those rules. For example, do you know how to conduct a voir dire examination? Do you know what are the grounds for excusing a juror for cause? Do you know what is hearsay? Do you know what are some of the exceptions to hearsay?
Yes, sir.
Do you know what is the proper way of impeaching a witness?
Yes, sir.
Okay. And how do you impeach a witness?
You must prove that they're not, basically what they're saying is the truth.
Okay, but how do you do that?
Following whatever you guys give, the guidelines and whatever rules you guys have.
Now, you have to know the rules.
It's something that I
Okay,
should be-
if you're not familiar with the rules of evidence, you'll find ways to impeach your witnesses if you're following the rules of evidence. Okay.
Another question,
Hmm?
at which point in, once you start the whole process, can I refer back to our, board?
You can hire an attorney at any point. Okay. So that's what you want to do? Before I go any further, because I can go further.
Yeah, but at some point I'll get there. I just.
Okay, now, do you know what character evidence is allowed? What character evidence is allowed in trial? Do you know when and how to offer or make proper objections?
No, sir.
Do you know when and how to move for a directed verdict? Do you know how to offer evidence to protect the record for appeal? Do you know the proper grounds for a mistrial? Are you aware that failure to timely move for a mistrial may waive crucial mistakes made by the state or this court?
Yes, sir.
Do you know how to request and object to jury instructions? Are you familiar with the Texas Rules of Criminal Procedure? Okay. Do you realize that those rules govern the way in which a criminal action is tried in court?
Yes, sir.
So I must advise you that, in my opinion, you would be far better defended by a trained attorney than by yourself. I think it is unwise for you to try to represent yourself. You're not familiar with the law. You're not familiar with the court procedures. You're not familiar with the rules of evidence. I would strongly urge you to try not to represent yourself. Now, in light of the penalty that you might suffer if you're found guilty, and in light of all the difficulties of representing yourself, is it still your desire to represent yourself and to give up your right to be represented by a lawyer?
At this time, yes.
Okay? So, is your decision entirely voluntarily on your part?
Yes, sir.
Okay? So at this time, the court finds that the defendant has knowingly and voluntarily waived his right to counsel. I will therefore permit him to represent himself. Now, Mr. Gorda, your case is going to be reset. You will be pro se. You'll have an opportunity to visit with the prosecutor to review the discovery. The discovery is the evidence that they have in the case against you. And therefore, your case will be reset to give you an opportunity to make arrangements with the state and to have access to the discovery. Okay? So your case is, let's give him a reset, give him a little extended reset since he's pro se.
May 1st.
Okay, your case will be reset to May 1st of 2026 to give you an opportunity to meet with the prosecutors and to go over the discovery. And then when you come back on May 1st, your case will be set for what is called an announcement. And what the announcement is, on that day, you will announce to the court, one, that whether or not you received the discovery, well, not received, but that you had access to the state's file, and whether or not you were able to, I guess, ascertain the information or the evidence that you need in order to prepare for trial. And then you will announce whether or not you need more time, whether or not you're ready to go to trial. And then based on how you answer, your case will either be set on what is called a pretrial docket,
Yeah.
it could be set on the trial docket, or it could be continued on the announcement docket. Okay, do you understand?
Yes, sir.
All right. So you're gonna have a seat in that first chair on the wall, wait for your name to be called. Once your name is called, you'll be free to go, and you have a blessed day. Howard Walker. Hold on. Excuse me. Okay, Mr. Walker, your full name is Howard K. Walker.
Yes, sir.
Mr. Walker, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Walker, you may put your hand down. How are you doing, Mr. Walker?
I'm good, and you?
I'm doing fine, thanks for asking. Mr. Walker, I have two documents before me. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Recognize this document?
Yes, sir.
Is this your signature on the line as titled defendant?
Yes, sir.
And are these your initials on the line that state
Yes, sir.
you would like to waive your right to an attorney and represent yourself?
Yes, sir.
I also have another document that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. Do you recognize this document?
Yes, sir.
And is this your signature on the line as titled
Yes,
defendant?
sir.
Now, Mr. Walker, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Good.
Mr. Walker, okay, I read your answers. Mr. Walker, see that you talked to the prosecutors about your case, is that correct?
Yes, sir.
And have you all been able to come to a plea bargain agreement?
No, it was not, and I told him that I wanted to attorney.
Oh, okay, so he needs to make his change on here. We're gonna, place his initials on the top. Okay, Mr. Walker. Okay, so your case will be reset to give you an opportunity to hire your own attorney.
Yes, sir.
Okay, now, Mr. Walker, you're gonna have a seat in that first chair on the wall, wait for your name to be called. Once your name is called, you'll be free to go, and you have a blessed day. Keila J. Bell. Okay, your name is, how you pronounce your first name?
Akiva.
Akila.
Yes, sir.
And it's Akila J. Bell. Now, earlier, your case was set for arraignment at 9, but you had two cases. And, you just arrived.
Oh, sir.
Hmm?
Oh, sir.
Okay. And, was your bondsman contact you?
No, I contacted them.
Okay,
I called them and they told me to try to hurry up and still making.
okay. Now, your case is set for an arraignment. Now, we're gonna need some paperwork. She's gonna give you some paperwork, and that I'll go over the paperwork with you.
No, Mr. Walker.
Okay. Now, the paperwork that's before you. Yeah, first document was the judge's explanation of rights to defendants without attorney. Okay, I'm going to go over that document with you. That document states that as a defendant in a criminal case, you have three options. Number one, you may hire an attorney. Do you understand that option? Number two, you may request that an attorney be appointed to represent you. Do you understand that option? And number three, you may represent yourself. Do you understand that option? Now, the first paragraph under number 3 states that if you want an attorney and you have enough money to hire an attorney, your case will be reset. Reset means you'll be given another court date to give you time to hire your attorney. The next paragraph below that states that if you want an attorney, but you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. In essence, you may ask the court to appoint an attorney to represent you, but you must first fill out a financial questionnaire so that the proper person can determine whether or not you qualify for a court-appointed attorney. Now, the financial questionnaire is a 3-page document that is also on the clipboard. It is titled Jefferson County Affidavit of Issues. Now, that document looks like this, okay? You would have to fill out the entire first page. On the second page, you fill out the top portion that's titled Defendant's Oath, and the middle portion that's titled Unsworn Declaration by Defendant. That's only if you are applying for a court-appointed attorney. So if you're not applying for a court-appointed attorney, you don't have to worry about this document. Do you understand? Okay, now the next sentence, next one sentence paragraph is for individuals who will be waiving their right to an attorney or giving up their right to have an attorney and representing themselves. If that's the case, if you would like to do that, then before you're able to do that, you would have to first fill out a document on that clipboard that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. You have to read this document, sign and date it. If you do not want to represent yourself, that is, if you are not waiving your right to have an attorney, you don't have to worry about this form. Okay? So now, if you are thinking about representing yourself, then you should be mindful, according to the paragraph that's in block form on that first page, it states, there are dangers and disadvantages of self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you, including outcome for you in your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, and child custody. Now, if you are representing yourself, you may change your mind at any time and request that an attorney be appointed to represent you. Now, at the bottom of that document, in bold letters, it states defendant's choice. Mark initials next to only one choice. If your choice is to hire your own attorney, you will place your initials on the first line to the left. You understand? If you have already hired an attorney to represent you, then you'll place your initials on the second line to the left and the name of the attorney on the line to the right. If you are applying for a court-appointed attorney, then you will place your initials on the third line to the left. If you have already been appointed a court-appointed attorney in your case, then you'll place your initials on the fourth line to the left and the name of the attorney on the line to the right. If you are waiving your right to an attorney, that is giving up your right to an attorney and representing yourself, you'll place your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines at the bottom of that document, then you will sign the name on the line that's titled Defendant, and you will date it today's date, March 10th, 2026. Do you understand? All right.
I have a question.
Yes.
If I do want to get my own lawyer, but have it in that time, what happens then while I be able to?
Okay. If you would like to hire your own attorney, let's say when you went out and talked to a couple of attorneys, and let's say they quoted you a fee, and let's say you didn't have enough time to get the fee before court. When you come back to court, you tell a court that you talked to an attorney, they quoted you a fee, you need more time to get the money to pay it, and we'll reset your case. Or they may quote you a fee and you may say, well, when you come back, you say, well, Judge, I can't afford to hire an attorney. Okay, we'll have you to fill out an affidavit and see if you qualify for a court appointed attorney. Okay, that's fine. Okay, so you're gonna place your initials on the first line to the left, at the bottom of that document. Gonna sign and date that document. Today's date is March 10th, and that's the only form you'd have to sign. Now, let me tell you this. At the top of that document, it states the state of Texas versus, right? And then there's a line. Print your name on that line. Okay? All right. Just have a seat at that table. When you finish, we'll call you back up and you'll be free to go. Hmm. You're gonna give it to her. Did you sign it? Date it? Okay. I need to. That's Bill.
Right here, Bill.
No, you're gonna come back up. I need to go with you. Thank you. Okay. Okay. Ms. Bell, would you please raise your right hand? Swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. You may put your hand down. I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? And is this your signature on the line that's titled defendant? Or these your initials on the line that state you would like to apply, that you would like to hire your own attorney and have your case reset? Okay? Now, before you signed it and initialed this document, did you read the document? Did you understand what you read? And is everything in this document true and correct to the best of your knowledge? Okay? Your case will be, well, your cases will be reset to give you time to hire your own attorney. Our court coordinator is going to reset your case or your cases. Once your cases are reset, you will be free to go and you have a blessed day. Thank you. You can stand in front of the court coordinator. Will you ever check some of these folks?
She got notes in there.
I see cash bond, reset mail to address on bond, reset mail to address on bond. Man. Somebody named Hopper. Now, do we know if we have any attorneys that was hired?
Yeah, well, I checked, let me check my email again. I checked this morning.
Okay, so
One, Shaniqua Washington has Marvin Provo already.
No, that case was rescinded because,
Evidence
Holmes
trustee.
representing her on the felony case.
Yeah, so she wasn't ever actually assigned to this case. She was just already her attorney
well,
Marva was appointed on the case.
on the felony.
No, on the-
but it had to be transferred.
But we had to transfer.
They had to resend.
So she
But
does.
do you know if that person is on the docket?
Custody.
Oh, they're in custody?
And they're set for an NTRP announcement in the 52nd for the 24th of March.
Yeah, she took care of it yesterday. Okay. Okay, Jeff County Court Law number 2 is back in session. Court is in session and calls number 25 CCCR 1972 case of style of state of Texas versus Saul R. Gaona. Saul Gaona was scheduled to be in court this morning at 9 a.m. At about 9 a.m., the court's bailiff called the name of Saul Gaona at the courthouse door. He did not answer. The time now is 11:28 a.m. on today's date, March 10th, 2026. Ms. Bailey, could you please call the name of Saul Gaona at the courthouse door?
No response, Your Honor.
Okay, Saul Gaona's name was just called again at the courthouse door. Saul Gaona did not answer. A reasonable time has passed to give Saul Gaona an opportunity to appear in court. State you have a motion. That motion will be granted. Saul Gaona's bond will be forfeited and warrant should be issued for his arrest. In cause number 25 CCCR 1972. Next case is cause number 25 CCCR 2412. Case is style the state of Texas versus Clayton J. Garlow. Clayton Garlow was scheduled to be in court this morning at 9 a.m. At about 9 a.m., Clayton Garlow's name was called at the courthouse door by the court's bailiff. Clayton Garlow did not answer. Clayton Garlow has not appeared in court since the court has been in session. At the time now is 11:29 a.m. on today's date, on March 10th, 2026. Ms. Bailiff, would you please call the name of Clayton Garlow at the courthouse door?
Clayton Garlow. Clayton Garlow. No response, Your Honor.
Okay, Clayton Garlow's name was just called again at the courthouse door. Clayton Garlow did not answer. Reasonable time has passed to give Mr. Garlow an opportunity to appear before he has not appeared in court. State, do you have a motion? That motion will be granted. Clayton Garlow's bond will be forfeited and warrant should be issued for his arrest in cause number 25 CCCR 2412. The next case is cause number 24 CCCR 0796. Case of style of state of Texas versus Christopher Joel Gonzalez. Christopher Gonzalez was scheduled to be in court this morning at 9 a.m. At about 9 a.m., court spirit called the name of Christopher Gonzalez at the courthouse door. He did not answer. Does not appear in court since the court has been in session. The time now is 11:30 a.m. on today's date, March 10th, 2026. Mr. Bailiff, would you please call the name of Christopher Gonzalez at the courthouse door?
Christopher Gonzalez. No response.
Okay. Christopher Gonzalez's name was called again at the courthouse door. Christopher Gonzalez did not answer. A reasonable time has passed to give Mr. Gonzalez the opportunity to appear in court. State you have a motion. That motion will be granted. Christopher Gonzalez's bond will be forfeited. Warrant should be issued for his arrest and cause number 24 CCCR 0796. Case. Next case is cause number 26CCCR 0100. Case is styled the state of Texas versus Joseph G. Hopper. Joseph Hopper was scheduled to be in court this morning at 9 a.m. At about 9 a.m., of course, we had to call the name of Joseph Hopper at the courthouse door. Joseph Hopper did not answer. He has not appeared in court since the court has been in session. The time now is 11:31 a.m. on today's date of March 10th, 2026. Ms. Bailiff, would you please call the name of Joseph Hopper at the courthouse door?
Joseph Hopper. Joseph Hopper. No response.
Okay. Joseph Hopper's name was called again at the courthouse door. Joseph Hopper did not answer. A reasonable time has passed to give Mr. Hopper an opportunity to appear in court. Is not appearing in court. State, do you have a motion? That motion will be granted. Joseph Hopper's bond will be forfeited and warrant should be issued for his arrest. In cause number 26CCCR 0100. Next case is cause number 24CCCR 2128. And the case is styled the state of Texas versus Galicia Robinson. Galicia Robinson is scheduled to be in court this morning at 9 a.m. At about 9 a.m. Court's bailiff called the name of Galicia Robinson at the courthouse door. Galicia Robinson did not answer. Galicia Robinson has not appeared in court since the court has been in session. The time now is 11:32 a.m. on today's date of March 10th, 2026. Ms. Bailiff, could you please call the name of Galicia Robinson at the courthouse door?
Galicia Robinson. No response, Rose.
Okay. Galicia Robinson's name was called again at the courthouse door. Galicia Robinson did not answer. A reasonable time has passed to give Ms. Robinson an opportunity to appear in court. She does not appear in court. State, do you have a motion? That motion will be granted. Galicia Robinson bond will be forfeited and a warrant should be issued for her arrest. Then cause number 24CCCR 2128. And this will conclude the calling of the court's arraignment docket on today's date, March 10th, 2026. In County Court at Law Number 2, Jefferson County, Texas, Judge Terrence Holmes presiding. Everyone, please have a blessed day. Prosecutors, you are excused.
Thank you, Judge.
You're welcome.